This civil rights action has come to be known for all the wrong reasons, says the judge. All plaintiff's counsel, Cynthia L. Pollock Esquire, has managed to accomplish is disrespecting this court as an institution and embarrassing herself in the eyes of many of its constituents. Ms. Pollock now contends that she is entitled to $727,000 in fees. That mindset is equal parts brazen and delusional. If Ms. Pollock is dumb, she is dumb like a fox. Such defiance ceases today. Hello everyone, good morning. I am Leonard French, your favorite copyright attorney. Thank you for joining me on the community-supported Lawful Masses Legal Education channel here on YouTube. And we have a Sunday show live 10 a.m. on Eastern on Twitch. So thank you very much for coming today. I am not going to disappoint you this Friday. We have a sort of new or seasonal segment called Lawyer Nightmares, where we're going to talk about stories that give lawyers nightmares. These sorts of, oh my god, I can't believe they did that. If I ever did that, I would be disbarred. And yeah, that's what these people are facing, is disciplinary action. So let's talk about the story of Cynthia Pollock. It was Cynthia Pollock's behavior in this and another case that led to the district court denying her motion for attorney's fees, finding that she violated the federal rules of civil procedure, Rule 11, which is about attorney conduct, not filing frivolous things and such, and violated 28 U.S.C. 1927, a law about counsel being liable for causing excessive costs in a matter. So the district court sanctioned Ms. Pollock to the tune of $25,000 twice, but said the violations will run concurrently, meaning she will pay $25,000 in total. Now, the appeals court doesn't necessarily have as much sass, but I wanted you to hear a little bit from the appeals court. Pollock represented a group of students who brought various civil rights claims against a school district and a teacher. During the first trial on those claims, Pollock made numerous statements that the court subsequently found were aimed at inflaming the jury. The jury returned a verdict for Pollock's clients. However, that verdict was a Pyrrhic victory because the trial court entered an order vacating the judgment and awarding a new trial based on Pollock's misconduct. The second trial was only against a school district. That trial resulted in a complete defense verdict. Before a third trial, which would have involved only the teacher, could begin, the teacher tendered a Rule 68 offer of judgment for $25,000, which Pollock's clients accepted. That settlement allowed for reasonable attorney's fees and costs as to the claims against the teacher only up to the date of the offer. Despite the express limitations of the settlement, Pollock submitted a fee petition requesting fees and costs purportedly incurred while representing her clients against both the school district and the teacher. The petition also includes fees and costs for work on the second trial, in which Pollock's clients were not the prevailing party and therefore not entitled to recover fees or costs. The total amount of the recovery from the teacher via the settlement was $25,000, yet Pollock submitted a fee petition in an amount exceeding $733,000. But that's not even the beginning of the story, everyone. Let's take a look at Young v. Smith, the case that started our Friday adventure into Lawyer Nightmares. This civil rights action has come to be known for all the wrong reasons, says the judge. Sad to say, after 10 years of protracted and unnecessarily contentious litigation, it appears that all plaintiff's counsel, Cynthia L. Pollock Esquire, has managed to accomplish is disrespecting this court as an institution and embarrassing herself in the eyes of many of its constituents. The instant chapter in this litigation stems from a fee petition submitted by Ms. Pollock for nearly $750,000. A fee petition that at times felt more like an attempted bank robbery than a genuine effort to recover a reasonable fee bill. Ms. Pollock prevailed on only one claim against one defendant in this odyssey of litigation, and I use the term prevailed exceptionally loosely. In fact, opposing counsel, after having offered settlements as high as $150,000 that Ms. Pollock rejected, made this case go away for a nuisance value of $25,000. That settlement was made as against one defendant on one claim in litigation that previously involved teachers, principals, school administrators, and a barrage of educational and civil rights claims. Because of that $25,000 nuisance settlement, effective pursuant to Federal Rule of Civil Procedure 68 in an offer of judgment, Ms. Pollock now contends that she is entitled to $727,000 in fees. That mindset is equal parts brazen and delusional. Now, before we continue, this is a really cool part of the Federal Rules of Civil Procedure that even some attorneys, yours included, didn't know about until someone told me about it, and I used it in a case successfully. It is an offer of judgment. It is a way that a losing party can cut off the litigation by basically saying, okay, we're guilty and here's how much we're offering to settle the case for. And if the actual judgment later on does not exceed that amount without attorney's fees and costs, then the attorney's fees and costs and such are cut off as of that offer of judgment. It is a way to help protect yourself from even non-frivolous attorney's fees and costs past a certain point. So in this case, the losing side or the opposing side, having previously offered the $150,000 and been denied, and now the litigation has gone on for 11 years, made an offer of judgment of $25,000, which does not include attorney's fees. So Attorney Pollock thought that she would be able to submit a bill for attorney's fees in addition to the $25,000. And she was initially correct. Let's continue. Counsel, as in attorneys, are quasi-officers of the court. They are expected to be careful and scrupulously honest in their representations to the court. They must exercise care, judgment, and ethical sensitivity in the delicate task of billing time and excluding hours that are vague, redundant, excessive, or unnecessary. The court retains the discretion to award whatever fee it determines appropriate, including no fee at all. Ms. Pollock has not only failed to live up to her duty as an officer of this court, she has, as on numerous prior occasions, thumbed her nose at it. Such defiance ceases today. Ms. Pollock's fee petition is mind-boggling and outrageously excessive. In fact, it is more than that. The vast majority of Ms. Pollock's entries are larded with excreta unbecoming of any attorney in this district. For example, in the portions of her fee bill that I reviewed before striking it in full, Ms. Pollock submitted upwards of 350 time entries with descriptions like correspondence with Patty, correspondence from Patty, correspondence with Patty about issue, correspondence from Patty about issue, correspondence with Patty thanking her for update, correspondence with Patty thanking for her information, correspondence with Patty checking in on Megan, correspondence with Patty advising she is putting stuff behind her, correspondence with Patty telling her she's glad she's giving herself a break, and so on, ad nauseum. Patty is actually Ms. Pollock's client's mother and not the client herself, just to bookend that for you. And the court notes, oddly, although Ms. Pollock billed excessive hours for administrative tasks, she remarkably devoted no more than 2 or 3 hours each time she actually engaged in substantive legal work, such as brief writing. These raw, unprocessed entries, which we will review, are inconsiderately supplied in what appears to be size 8-point font and smaller, comprising 44 separate pages, and frankly should sicken both bench and bar. Ms. Pollock has previously managed to resolve Rule 11 motions levied against her through extrajudicial means in a 2005 case, and both the United States Court of Appeals for the Third Circuit and the judges of this district court have penned what can only be described as a worn jurisprudence on Ms. Pollock's vexatious litigation conduct and outlandish fee petitions. Courts have had to weed through pages of inappropriate entries, reduce Ms. Pollock's submissions by several $100,000, and warn Ms. Pollock repeatedly. Suffice it to say, Ms. Pollock is simply not getting the message. Ms. Pollock has edged precariously close to the operative ethical boundaries by billing every incoming and outgoing correspondence in separate 6-minute entries or more. Thus, even if it took Ms. Pollock 1 minute to read an email and 1 minute to respond back, 2 minutes total, she has billed all of those communications, and hundreds of times over, in 2 separate 6-minute increments. Such practice essentially pads her time in 10-minute increments, 12 minutes versus 2, and reeks both of impropriety and lack of judgment. All of these details will be included in my submission of this matter to the Disciplinary Board of the Supreme Court of Pennsylvania for that regulatory body's review. Holy mackerel! So she's getting referred to the bar for disciplinary action as well. Now, let me tell you a little bit about the 4-minute rule. It is an unwritten, well, I'm sure somebody's written it, and it's definitely going to be in this video, so there it's written. The 4-minute rule is one of those guideline rules. You're not going to find it in the law or anything. But when you bill in these 6-minute increments or 1/10 of an hour, which is a standard billing practice, there is a sort of way to cover your butt, CYA, to make sure that you don't violate ethical rules quite so easily. The 4-minute rule does not mean that you won't violate ethical rules. It's just a guideline so you can sort of gauge, hey, if I'm under the 4-minute rule, I'm probably not really ethically sound here. And the 4-minute rule is basically that you shouldn't start billing the client until you spent 4 minutes doing something. It doesn't mean that you should only engage in things that are less than 4 minutes so you don't have to bill the client. It's sort of a guideline, like I said. You want to avoid billing for small things. You want to avoid those 0.1, 0.1, 0.1 on your bills. Another way to say it, instead of calling it the 4-minute rule, is that you want to send bills to your clients that they want to pay. That sounds obvious. That sounds also a little weird, like who would want to pay a bill anyway? But if you write the bill properly and you include line items with descriptions, and those descriptions are meaningful, spoke to client about such and such, client advised to do such and such, or it was decided how we would proceed this way or something. One line item should be that. The next line item should be, we proceeded as such and such, and the court did this. And the next line item should be, and we reacted this way. And all of those line items that you need to fill those in, spoke to the paralegal, or those can all be in there, but they have to be with some kind of meaning, not, well, why don't I just spoil it now? Let's go to the Pollock fee petition so that you can see what the court had to deal with here. This is a 98-page document, and it looks like this. I'm just going to scroll through here so you can sort of get an idea that it doesn't change. It's the same sort of drivel over and over and over again. We can pick any page and start to zoom in, and you'll see what the judge is talking about. Legal assistant, additional preparation of deposition summary. Okay, that sounds fine. And then down here, preparation for deposition summary, preparation of depositions, additional preparation, additional preparation, additional preparation, additional preparation. Does any of this give you any idea what the preparation was? What do you mean? What's the additional preparation? Reviewing the testimony of so-and-so for such and such would be a much more appropriate entry. And you would want to be doing that for every single entry. If you're using your timekeeping software properly, you're doing this as your timekeeping. You're not just hitting record and recording your time, and then next one is, and the Untitled 1, Untitled 2, Untitled 3, and then having to fill them in later is not the proper way to do it. Is not the proper way to do it. And this is what gives lawyers nightmares, because if we forget to do this and then we go back and fill it in and the judge is mad at us, look what the judge can do. Wipe out your entire fee and then charge you with the amount of money because you're being, frankly, a little bit of a dickhead. So, having seen that, let's go back to Ms. Pollock edging precariously close and getting referred to the Supreme Court Disciplinary Board. Ms. Pollock's conduct is ripe for sanctioning because she submitted the instant fee bill no less than 5 months after the judge wrote a thorough dissertation on the improprieties of such fee bills in a case that was litigated by Ms. Pollock herself. In that decision, the judge set forth thorough examples of improper and excessive entries before also trimming the reasonable hourly rate. So too does it follow on the heels of a decision by another judge that was affirmed by the Third Circuit, in which he denied one of Ms. Pollock's excessive fee bills altogether. What was Ms. Pollock's response to these unequivocal rebukes? She immediately submitted another, arguably more questionable petition to me within months of those decisions. This misconduct and this utter waste of our district's resources must stop. Fee motions are not meant to spawn parallel litigations, and civil rights cases are not get-rich-quick tickets. To the extent that Ms. Pollock or any other attorney in this district misperceives either of those facts, I have no qualms joining the chorus that seeks to set such behavior straight. If that was not enough, perhaps the most repugnant of all aspects of Ms. Pollock's fee petition is that she asks to be compensated for time necessitated by her own earlier misconduct. Strikingly, the defendants here were granted a new trial, a remarkably rare remedy in light of a tainted jury verdict attributable to Ms. Pollock's inflammatory conduct in open court. She has now billed not only for the time associated with that trial, but also for additional time and preparation necessitated by what can only be described as willful, bad faith, and vexatious behavior. So too has she billed for the subsequent trial and all of its attendant time. Not only was that trial a do-over of her own making, but it also resulted in a complete defense verdict. Now, a mistrial is not a with prejudice dismissal of the case, meaning the case can be filed again if there's a mistrial and cannot be filed again if it had been dismissed with prejudice. So she refiles the case, gets this Rule 68 offer of judgment in the retrial or relitigation of the case from the first time against the teacher. They make this $25,000 Rule 68 offer of judgment, and she accepts, which means that she can now submit a fee petition for her attorney's fees that her client would normally have to pay. She would normally be able to submit a reasonable attorney's fee. Believe it or not, attorneys are bound by a law, by an ethical rule of professional responsibility, not to charge an excessive fee. So even though there are high fees, those fees, if challenged, could be reduced to a more reasonable fee if they are not reasonable. That's what we're talking about in this case. Instead of billing for the time it took her to get that Rule 68 offer of judgment in that final case, she billed for all 11 years of that litigation. So the judge is about to provide some context as to why Ms. Pollock's billing for such time is exceedingly shameless. He notes that his colleague, Yvette Kane, judge, presided over the first trial in this action and granted the attendant new trial motion all before this judge came to the bench. She described Ms. Pollock's behavior as follows. The court finds that plaintiff's counsel did engage in improper conduct during the course of trial by persistently asking questions that had been ruled improper for the purpose of characterizing or mischaracterizing evidence. For example, unprompted and in the presence of the jury, plaintiff's counsel exclaimed, "I'm going to show his nakednews.com, what he showed to the children, which absolutely goes to the hostile educational atmosphere because of the fact that these girls had thongs and he shows this to children that are 16 years old." The judge says counsel. Ms. Pollock finishes, in their bras and thongs. That plaintiff's counsel's conduct was improper is obvious. Throughout the course of trial, counsel alternatively asked about evidence that had been ruled inadmissible, asked for lay opinion testimony, and asked for testimony without foundation. Testimony without foundation means the attorney hasn't asked the previous questions. That, were you there? Did you see? Did you perceive the events? Etc. Basically, the attorney has not established that the witness is an actual witness, as opposed to some random person. These things are important. You could just pull some random person off the street, pay him $50, and be like, "Hey, just say what I tell you to say," and that has happened. I'm not saying that's happened in this case, but you have to authenticate the witness. You have to lay foundation for their testimony. The purpose of this tactic was apparently to inflame the jurors by repeating outrageous conduct that is alleged to have occurred as fact enough times so that the jurors would believe it really did occur, even if no evidence was introduced that would support such a finding. To cite just one example, the court notes that counsel asked various witnesses about the defendant discussing masturbation a total of 7 times during the trial, in addition to mentioning it in her closing argument. However, there is no evidence in the record that the defendant ever even used the word in plaintiff's presence. The effect of counsel's conduct is obvious. The jury was inflamed and misled into believing that there was evidence that the defendant discussed masturbation with the plaintiff. On appeal, the Third Circuit affirmed Judge Kane's decision, noting that she cataloged an extensive record of misconduct by Pollock throughout the first trial. So that the record is clear up front, I also note that this case was originally assigned to Judge James Munley prior to Judge Kane. As defense counsel characterizes it, Ms. Pollock's obdurate behavior commenced here when she filed a motion asking that Judge Munley recuse himself because he was biased against her. In fact, that was not even the first time that Ms. Pollock moved to recuse a sitting judge in this district. To the contrary, in a 2008 matter captioned Hill v. City of Scranton, Judge Jones denied a motion to recuse in which Ms. Pollock, at bottom, argued that because we have in her view been mean to her, we should now depart the case, as well as presumably any other case in which she is involved that lands on our docket. Judge Jones observed, "We have never imposed any manner of sanctions against Ms. Pollock despite our warnings." Judge Jones advised Ms. Pollock to endeavor to be more appropriate in her interactions with this court, since doing so would immeasurably enhance her advocacy skills and thus serve her clients better. Some say that engaging in the same improper conduct time and time again while expecting a different result is indicative of mental instability, and that may be. But if Ms. Pollock is dumb, she is dumb like a fox. Indeed, in connection with Ms. Pollock's questionable fee petition, I was forced to conduct what devolved into perhaps the strangest show cause hearing in my tenure with this court. On July 13th, 2017, I invited Ms. Pollock along with defense counsel to speak to the propriety of sanctions in this matter as punishment for Ms. Pollock's vexatious conduct and legally unsupported fee request. Ms. Pollock objected to my holding the hearing, but he overruled her objection, saying, "We have held that if reasonable market rates are in dispute, a hearing must be conducted." What happened next was remarkable. For half a day, I was transported to a universe devoid of logical principles and fundamental notions of relevance. Ms. Pollock's strange and obstreperous conduct at the hearing also flaunted any semblance of propriety and decorum in federal court, sadly hearkening back to the time I previously endured a week-long trial in this matter. During the hearing, I requested the presence of additional court security guards and an assistant U.S. Marshal, as it appeared that Ms. Pollock was on the verge of a breakdown on no less than 2 separate occasions. Ms. Pollock's edginess was palpable. She refused to agree, for instance, that 5 months' time separates February from July, and when I confronted her with all of the previous authorities deeming her very same submissions as non-compensable, indeed most using the same exact words as present here, she rebuffed my invitation to submit an amended motion, reasoning instead that amendment would make it appear as if she had done something wrong. Considering the frequency with which we permit and encourage amendment in the federal system, I was entirely at a loss to have heard that response. Presumably, permissive amendment beats monetary sanctions. Further, I asked Ms. Pollock at the show cause hearing why she billed in the manner she did and why she failed to revise her billing entries before submitting them. Rather remarkably, she suggested that it is her right to submit whatever billed entries she so pleases, valid or not, and that it is opposing counsel's and the court's job to parse through her fee bill, challenging those that may be invalid. This is an astonishing misperception, or perhaps a blatantly dishonest response. Make no mistake, it is wholly inaccurate. Prevailing plaintiffs have a duty to make some reasonable effort to weed out the fees relating to the unsuccessful claims. The petitioning attorney has an obligation to weed out hours that are excessive, redundant, or otherwise unnecessary from his or her fee request, and bears the burden of proving that the number of hours expended was reasonable. Hours that are not properly billed to one's client are also not properly billed to one's adversary, pursuant to statutory authority. This restriction is designed to encourage a prevailing party requesting attorney's fees to exercise the same billing judgment that would have been exercised in the ordinary course of private practice. Accordingly, a lawyer must not abandon self-restraint or careful billing judgment because of the expectation that the obligation to pay the fee will be statutorily shifted to the losing party. That Ms. Pollock submitted her fee bill without weeding out improper entries is grounds alone to deny it and impose sanctions. In perhaps the second strangest portion of the show cause hearing, Ms. Pollock called opposing counsel John Freund, Esquire, as a witness, as if on cross-examination, a tactic that she repeats endlessly and ineffectively at trial, and proceeds to pepper him with argumentative questions, which he unsurprisingly handled with impugnable professionalism. Nothing in Ms. Pollock's cross-examination of Mr. Freund gave me pause. To the contrary, Ms. Pollock's questioning of her adversary, which I viewed as largely inappropriate from the outset, went over like the descent of the Hindenburg. It was a show cause hearing turned circus under the big top, much like Ms. Pollock's prior trial performance. Oddly, none of Ms. Pollock's fee affiants showed up to testify on her behalf. Even her clients were notably absent. The judge notes, unfortunately, the extent to which Ms. Pollock's clients even continue to be aware of this action or simultaneously sanction its continuance has been unclear to me for at least the past year. Whether they were aware of the $150,000 offer and turned it down on a knowing and informed basis is also unclear to me. Instead, in recent memory and perhaps since its inception in truth, Ms. Pollock has cannibalized her client's lawsuit so that it serves one end, collection of what she believed would be a fat fee bill. Finally, the most troubling portion of the hearing occurred at its conclusion, when Anthony Trazzolillo, Esquire, an attorney who purportedly is engaged in a romantic relationship with Ms. Pollock, and who had been seated in the gallery to presumably show his support, sprang from his seat as I left the bench, approaching opposing counsel's table, cursing at Mr. Freund for jumping on the Rule 11 bandwagon. Mr. Trazzolillo directed a few bullshits and goddams in Mr. Freund's direction and began to invade his physical space. Court staff asked the security guards to separate Mr. Trazzolillo from opposing counsel before he and Ms. Pollock were directed out of the building. At my direction, an assistant U.S. Marshal was asked to escort Mr. Freund and his paralegal to their vehicle. I am told that my experiences with Ms. Pollock are not unique. In fact, it appears that she experienced a brief hiatus in her legal practice in the summer of 2015 when she was reported missing by her mother and was charged with trespassing at a local hospital. According to state police, Cynthia Pollock has been found. They have not released any other information. A Pittstown lawyer was reported missing Sunday and has been charged with trespassing the day before at Moses Taylor Hospital. She apparently went to the hospital for a test. She didn't want to complete the requirements of getting the test, and so they asked her to leave. She refused to leave. She lay down defiantly in the hospital bed. The police officer even encouraged her to leave before arresting her, and then she was processed through Lackawanna County Booking Center and released because the charge was not serious enough to warrant an arraignment. It is a third-degree misdemeanor, the lowest grade of misdemeanor in Pennsylvania. What a weird... Just what weirdness is this? How is this person... Well, I don't know how much longer this person will be an attorney. We'll see. All of that nonsense aside, this motion is about the impropriety of Ms. Pollock's present fee petition. the waste of public and private resources it has engendered, and her persistent refusal to heed prior warnings of this court and the Third Circuit. To what have all of these reprimands led? In perhaps her grand finale, Ms. Pollock asked to be paid $750,000 for time that she purportedly expended to secure a $25,000 settlement. The entries supporting that request are so vague, duplicative, and improper, it is denied in full. In sum, because Ms. Pollock's fee petition in the amount of $727,000 is unreasonable in light of the outcome that she achieved in this litigation on behalf of her client, and was excessive and wholly unsupported by the billing records and the applicable law, and vexatiously multiplied this case's proceedings, I will deny Ms. Pollock's motion for fees in full. Moreover, Ms. Pollock's conduct will be referred to the Disciplinary Board of the Supreme Court of Pennsylvania. In addition, because Ms. Pollock's submissions simultaneously violated 28 U.S.C. 1927 and Rule 11 of the Federal Rules of Civil Procedure, I will impose sanctions in the amount of $25,000 under each provision to run concurrently. Monetary sanctions are the minimum appropriate remedial measure because Ms. Pollock's conduct follows a number of detailed decisions that instructed her to cease filing such excessive petitions. Last, I will encourage my colleagues to consider whether the Board of Judges should revoke the general admission of practitioners who take advantage of the submissions of fee petitions in civil rights cases in this district. And then the appeals court says many of the same things that the district court said, which we've already gone over. And then the appeals court concludes, because civil rights laws depend greatly upon private enforcement, Congress thought that fee awards were essential if private citizens were to have a meaningful opportunity to vindicate the important congressional policies contained in the civil rights laws. Nothing that we have said today in response to the very unique circumstances here should in any way be interpreted as mitigating the necessity of fee awards. Our appreciation of those awards, or our appreciation of the many attorneys who extend themselves and their services to vindicate the civil rights of their clients. We emphasize, therefore, that although we affirm the denial of the fee petition in total here, it is the exceedingly rare case where such a drastic action is appropriate. Nevertheless, on this record, for all the reasons set forth above, we have no difficulty affirming the judgment of the district court. So what did you think of that, my lawful masses? That was some pretty screwed up stuff, and definitely unbecoming of an attorney. I hope that person either loses their law license or learns their lesson, because I can't imagine them continuing as is much longer. And although she has been referred to the disciplinary board, I do not see any action being taken on her record here. This is from the disciplinary board of the Supreme Court. So if they are taking action, they have not done it yet. These things do take a long time. Usually it's a couple years before the disciplinary board catches up with you. She might even be going back and forth with them right now, and they just haven't put anything on her record until she's either convicted or something. I don't know. So that's a very interesting and weird lawyer nightmare that I thought I would share for you this Friday, this fine Friday. Thank you all for joining me, my lawful masses. Thank you for your support. This is a community-supported channel that would not be possible if it were not for your financial support, especially your support on patreon.com/ljfrench. Thank you very much to our supporters in the month of October. At the $50 level, we have Jonathan Doe, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Sean McNamara, William Gonzalez, Michael Pearce, Grunkle Tia Marie, Terry Crisp, Richard Fournier, Michael Jones, Spirit Bear, and Jan Negrey. Thank you very much for your support, and thank you to the 200 plus, $5 plus supporters that are scrolling on the LED panel behind me and will be on the crawl of this video when I edit this down. You guys have a great weekend. I will see you Sunday morning at 10 a.m. Eastern U.S. time on twitch.tv/LeonardFrench, LeonardFrench. We're working on getting our vanity name there. I think I messed it up 6 months ago, so we have to try again. Anyway, have a great weekend. I will see you Sunday. I am Leonard French, your favorite copyright attorney. You are my lawful masses, and this is our legal education channel here on YouTube. Love you all so very much. Have a great weekend. We emphasize, therefore, that although we affirm the denial of the P petition, Okay. What are we drinking today? It is Fentiman's Curiosity Cola. I'm only allowed to have this in the morning because the caffeine won't wear off in time if I have it in the afternoon. That's what it's like to be Leonard French.